Another big question we get when people come in is, how do I avoid probate? Everybody has heard this word probate out there, and they kind of know what it is, and many people have actually dealt with it before, but they know they want to avoid it, but they don't really understand even what it is and what causes probate. So today I'm going to try and explain it to you like I explain it to clients in my office. And suppose that I had a piece of something or an asset, and I wanted to transfer title to you today. That would require me to sign some kind of a legal document, correct? If it was land, I would have to sign a deed, or if it was a car, I'd have to sign the car title, or if I was transferring money from my bank account to yours, I'd have to sign a wire or a check or something. But my signature on some type of a legal document is required to take it out of my name and put it into your name, for example. Well, guess what I can't do when I'm dead? I can no longer sign my name, obviously. At least I'm not supposed to be able to sign it. And so if I have title to something and it's solely in my name and I die, that means typically title just got stuck, because clearly I'm no longer capable of signing my name and nobody else is allowed to sign it for me. Quick side note, a lot of times people think that if I've given a power of attorney to somebody where I've authorized them to sign my name, that after I'm dead, they can still use that power of attorney to sign my name. Not true. A power of attorney dies with the person who gave the power of attorney. So if I've given my spouse a power of attorney to sign my name, once I'm dead, she can no longer sign my name. So don't think that you can avoid probate by using a power of attorney. That is not correct in any of the states, certainly not here in Florida. So what happens if title is just in my name and I die? Clearly, I can no longer sign my name. That means title just got stuck, as you'll see with a few exceptions. But generally speaking, let's say it's a piece of real estate, it's in my name, I just died, title is stuck. That means that somebody has to go to court now to transfer that title, since I can no longer sign my name on a deed and nobody else can sign my name on a deed. So that process that we go through, the court process, is what's called probate. And that's all probate is, really. It's having to get the court involved to deal with assets in which the title got stuck. So how do I avoid having to go through probate? How do I avoid that court process? Simple. Just don't let it get stuck. Well, thanks, Bill. That's very enlightening. Can you elaborate on that? And that's, of course, what we do here is we try to make sure that everybody's plan to not have to go, or at least the majority, if not all of their assets, not have to go through that process. So how do we do it? Well, the easy way, or some of the ways rather, not necessarily easy, but probably the easiest, is depending on how title was held at the time that I died. For example, instead of that title being solely in my name, let's suppose that it was jointly owned by myself and my spouse, so that both of our names were on title the moment I died. At least in Florida and in a lot of other states, if you own something jointly with the spouse, the default or the presumption is that you each own 100%. And thereby, if I die, my spouse still owns the 100%, so nothing gets stuck. That presumption is a little bit different from state to state, and it's certainly different if you hold it with a non-spouse. So example, if myself and a sibling held something together, unless the deed specifically says otherwise, each of us own our 50% or whatever the percentage is. Therefore, if I die, my 50% gets stuck, or if my sibling dies, their 50% gets stuck and thereby has to go through the court. So just owning it jointly is not in and of itself enough to avoid it getting stuck and thereby causing probate. It has to be held in a way that's what's called rights of survivorship. So the title has to be held so that you're either married or you've clearly indicated that you want that right of survivorship. But that is one way to keep it from getting stuck, is by owning it jointly with somebody and having that right of survivorship. Pretty easy way, pretty common as between spouses. Another way is if the type of asset that we're dealing with allows us to name a beneficiary, and you've in fact named that beneficiary with the bank or the insurance company or whoever that account or asset is with, and three things, that person survives you. So if I have, for example, an individual retirement account, the I in IRA stands for individual, so I can't have a joint retirement account, which means that if I die, yes, title got stuck because it was individually owned, but as long as I've named with that company the beneficiary where I want it to get paid and that person survives me, then that's where it goes. It doesn't get stuck. It doesn't need to go to probate, and it's very simple to do. Another way to avoid probate is by a trust. And this is what we do a lot. And so let's go back to the joint ownership. If I have it, jointly owned between my spouse and I die, she owns it, vice versa, I own it. But if we both die, title just got stuck. And with real estate, there's not a very easy way to own it in a like a payable on death method or anything like that. So this is typically where trusts come in, and trusts allow us to create this entity, if you will, this kind of third party. I call it a bucket in my office to own the property for us. So I create trust. I then do a deed and make the trust the owner of that property. And then if I die, title doesn't get stuck. Title is still owned by the trust, and the trust tells it where to go, thereby avoiding probate because it doesn't get stuck. Pretty simple. There's some other ways to avoid probate. This is where you start hearing terms like ladybird deed and life estate deeds. It's a way of kind of time sharing up the ownership of your property, so that if I go ahead and sign a deed giving somebody else all the rights and ownership after I'm dead, close to a payable on death, or at least as close as we can when it comes to real estate. However, it's a little more complicated than that. Sometimes we can't undo it. If we want to sell it or refinance it, it can cause issues. But that's kind of what probate is. It's when title gets stuck and we have to go to court. How do we avoid probate? Just don't let it get stuck. You got to find the right strategy for you and what works best for you and your assets. And that's usually where somebody like us comes in to help you understand what assets you have and what's the best way to get them to the right people, but without getting stuck and therefore going through probate. So hopefully that helps explain probate and how we oftentimes avoid it.